not like the abuse of power, and so the abuse of the law, I think, is very similar. If you're going to exploit a right that you have in a way that it's not intended, I just don't think people should get away with that. I think that attracts me to equity law, which is more directly based on doing the right thing. So equity is a system of judge-made law. It developed to prevent the law's abuse. It developed to prevent defects in the law because the law is general, it's made in advance, and so equity operates as a safety valve on the spot at the time of the decision to make sure the law achieves its purposes. It's almost directly based on moral values, ethical ideals like following the golden rule, preventing people from taking advantage of their own wrong. So equity and law in the sense of law being a very strict and equity being more discretionary, judges have more leeway. Obviously that's going to be a delicate balance. Equity is going to have a bright side because it is flexible, because it can tailor the circumstances of the case, adapt to that situation that the lawmaker originally, intended. But there could be a dark side. It could be too subjective. The judge could have too much discretion. There might not be constraints within the doctrine or the principle they're applying. And then we have uneven law, and then we have unfair, equity. Prior to academia, I was a business litigator. And during that litigation practice, equitable principles and doctrines came up all the time. Entire cases were devoted to equity. My longest case was 9 years. It was an equity case, all equitable doctrines and principles. There was very little to no analyses of these doctrines, particularly these defenses, such as unclean hands, which is the book is about. And so when I transitioned to academia, I am writing the book that I wanted to have when I was a lawyer.